For more on this story, let's bring in Jessica Gracie, who is a PhD candidate at the University of York, and she specialises in the legal implications of the gig economy. Hi there, Jess.
Hi, Holly.
Great to have your company on this. Thanks so much for taking the time to come on. Can you just give us a summary of the story? What's happened so far and what does it mean for Uber?
Yeah, of course. So, back in 2016, a number of drivers, including the lead claimants, James Farrar and Yazine Aslam, they took their claim to a UK employment tribunal, stating that they were workers. And actually, the employment tribunal in the UK agreed with that assessment and held that they were workers. And Uber's response to this was to appeal it all the way up to the Supreme Court in the UK, who also agreed with the assessment of the Employment Tribunal. So this means that Uber drivers were then entitled to things like the right to the minimum wage and the right to paid leave. But Uber's response to this initially, just right after the judgment, was that this decision only applies to the few claimants in the case, doesn't apply to the rest of the drivers. But their stance on this seems to have changed just in the last couple of days.
Absolutely. We know it's been a huge decision for Uber. Can you just elaborate exactly what Uber's offers have been to their drivers?
Of course, yeah. So it looks like Uber are wanting to reclassify their drivers now as workers, and they're offering them a guaranteed minimum wage, access to pension schemes, holiday pay to be accrued, and protection through insurance schemes for things like illness. But this only applies, as we can see at the moment, to drivers over the age of 25. But for those drivers, it does seem like their day-to-day life at work won't change too dramatically, because they're still going to be able to kind of maintain that flexibility that many of them really do value.
So sort of got the best of both worlds there. Just continuing on this though, is this complying with the decision that was made in the Supreme Court?
Well, this is what's really interesting, actually. So it looks like they're only complying in part with the decision. So the Supreme Court had two questions to answer. The first was, are these drivers workers? And the second was, if they are workers, then what time does that apply to? And of course, the Supreme Court held that they are workers. But crucially, they said that they're workers when they're switched onto the app, when they're in their territory and they're ready and willing to accept trips. But it looks like Uber's offer only applies to times where drivers have already accepted a trip. So periods of time when they're in their area waiting for trips, these benefits won't apply to those times. So I think there are some conversations going on right now, thinking about the extent to which this is going to be shortchanging drivers and how they might proceed from here.
Yeah, that's what I was just about to ask you. That what do you think is going to happen from here, and then going on further than that, how is this going to affect other workers in the wider gig I guess industry?
Yeah, well, we could potentially see more litigation from Uber drivers to try and enforce that part of the decision. I mean, I hope that's not the case, because the previous decision that we've seen in February, it was 5 or 6 years in the making, so that's a long time to get a resolution. But it may be, hopefully, that Uber will work collectively with trade unions and other stakeholders, to really iron out these issues. But litigation is a possibility. But I think importantly, what the decision of the Supreme Court and, Uber's decision to reclassify its drivers, it has shown that, flexibility isn't incompatible with employment protections. So I think, this has set a real precedent for other platforms in the gig economy. So we could see a lot of litigation in relation to other platforms, but, that could really bring this idea of flexible labour in the gig economy or platform labour up to the standards of the 21st century.
Absolutely. It's definitely a landmark decision there. Well, thanks so much for your time, Jess, and it's wonderful to get your expertise on this. So thanks so much for taking the time to come on.
Thanks for having me, Holly.
Jessica Gracie there.